Hello, my name is Adam Reiki. Welcome to Thai Legal Studies. Today I'm in discussion with Dr. Lasse Schuldt, and we're going to be talking about all of the articles in our first issue. We thought we'd record our conversation, video podcast style, and upload it so you can get a preview of everything that's coming out in this issue. To read all of the articles, click the link in the description box. That will take you to our website. All of the articles are open access, free of charge. So here's my discussion with Lasse. I hope you enjoy.
Yeah, so hi Adam, thanks a lot for this opportunity to talk about the first issue here of Thai Legal Studies. Maybe just a few words about myself. My name is Lasse Schuldt. I'm a lecturer at Thammasat University, and I am the deputy, or one of the deputy chief editors, together with you, obviously, of Thai Legal Studies.
Yeah,
right.
One of two, a very exclusive club. Great. So today, as I mentioned, I think in the introduction, we will be going through the contents, all the articles of our first issue, our inaugural issue of Thai Legal Studies, and we're going to try to go through them in the order that they will appear in the final issue. What I will do as well is I will put on the YouTube video chapters, so you can skip to the article that you're interested in, or you can, of course, watch the whole thing start to finish and hear our thoughts about each one. So what we did as well, our workflow process in Thai Legal Studies is that each of us kind of takes charge of an article each, or half of the articles of an issue, and we send that out to kind of subject editors, and they send out to reviewers. So I haven't heard anything about Lasse's articles, and Lasse hasn't heard anything about my articles, with one exception, which is the final article that we'll talk about, which was in fact written by Lasse. So Lasse is the...
That's right.
We have an author interview at the same time, so I will ask you about that, because I'll just get it wrong if I say what I thought it was about. Okay, so the first... shall I start? Do you want to start?
Yeah, why not? Please go ahead with the first article.
Okay. So the first article is by Chris Baker and Pasuk Phongpaichit. It's called "The Child is the Betel Tray: Making Law and Love in Ayutthaya, Siam." We're very honoured at Thai Legal Studies in our first issue to have an article by Chris Baker and Pasuk Phongpaichit, who are obviously Thai history legends, and they've started to write stuff about Thai law recently as well. So perhaps their latest book, or one of their recent books, was about palace law in the time of Ayutthaya. And then this is another article, or an article about a similar time period. Now, what they did in this article, and this is a fabulous article, by the way, I think it's really brilliant, is that they looked at one of the laws in the Three Seals Code. So the Three Seals Code was in theory, it was like a compilation of the laws of Ayutthaya that was made in 1804, after the destruction of Ayutthaya. And then the Three Seals Code was kind of the law of Bangkok and central Thailand, at least, during the 19th century, until we get to the modern, or the current, civil and commercial code. But why I find this article really fascinating, what they did in it, is that they took one of the laws within this Three Seals Code, which is the law on husband and wife, and they sort of looked at it kind of afresh, and they made this very sort of what now feels like such an obvious point. One of these things where they say it and then you think, oh well, of course, is that they sort of said that the way that we look at it now is very coloured by our idea of what law is. So and it is laid out. It's sort of in some ways like a modern law, or like law that we have these days, which is that it has kind of sections, and it's got sort of a preamble at the start. So we think of it in the same way as a modern law, but actually it probably wasn't that, and that's really sort of imposing our kind of modern view of what law is on this law from a different time and a different culture. And they said that what their article is about is they do a sort of analysis of it, like a linguistic analysis of it, and they argue that it's more of an archive. So it's almost like it's perhaps a collection of maybe some different judgments in particular circumstances, or some decrees by some kings maybe as well, and it's kind of like it's sort of advice about how to make a decision in different cases. So it's perhaps more like that. And also within the language as well, like you can see as well, the language changes quite differently, and it's quite different language in different sections, which maybe suggests that we've got a lot of time periods here, and sort of the complexity of the language changes. And there's also things like they use the phrase like editorial, graphic portrayal, poetic phrasing, wordplay. But there's a lot of sort of quite colourful language, and wordplay and sort of interesting things with sounds, which suggests again maybe it has perhaps it's got a slightly different function. So perhaps these were read out in court for judgments, sort of read out publicly or something, because if it was just used in the same way as laws these days, why would you write it like that? Why would you have that sort of wordplay?
Right.
So yeah, I thought it was really fascinating. I think it's really great article.
Yeah, that's really interesting. Almost like the Corpus Juris Civilis, right? Like a collection of laws, but also of maybe some decisions. Mostly, I think in the Three Seals Code from the period of Ayutthaya, right? And then they collected it over several years, but they collected basically the laws of hundreds of years before, right?
Yeah, I think so. Yeah, that's sort of my understanding of it. But it's sort of I agree. And it also reminded me again from a sort of English law, common law perspective. It made me think of the sort of early days of common law, where again they kind of did the same thing with the yearbooks and things like that, where they sort of gathered together court judgments on an issue. So it does seem like it's a few of those things. But what's interesting as well is that maybe it's not just like judgments. It's also it's perhaps a whole bunch of different things. So maybe it's kind of decrees of kings for particular circumstances. They also kind of say that in most circumstances as well, if you look at what the kind of result is, so what the judge would order, it's mostly kind of around sort of conciliation rather than punishment. There is punishment for adultery in particular, but for lots of other kind of breakdowns in relationships, it's a lot of conciliation as well. And so again, it's sort of, I don't know, it's like it does really make you look at this stuff like afresh again for the first time. And because I think I've been doing the same perhaps as lots of people that they say have been doing, whereas I just unconsciously kind of treated it as though it's law, as though it's like just a civil code that was around before the current civil code, and I kind of just assumed that it kind of worked in the same way. But of course it doesn't. Of course it doesn't. That isn't necessarily the case.
Yeah. Really interesting. That seems to be really then an important archive, as you say, of hundreds of years of development of Thai law that are then somehow encapsulated there into this one collection, basically, right? Yeah,
exactly. Yeah, and that's the other thing as well. Again, with this sort of our modern viewpoint, thinking in the time in which we live, there's the temptation to think this is all kind of passed at the same time with some sort of rationalized purpose, that this is all supposed to fit together, and give some complete framework around what the law of husband and wife is. But again, there's no reason why people at the time thought of it that way at all, and there's no reason why it was necessarily used like that either. And that's why I really like this article, is because when I read it, it suddenly seemed so obvious. It seems so simple and so obvious when the way that they put it. I'm like, well, yeah, of course I've been trapped in my own box of thinking all this time. So I think it's a fabulous article, and these are massive experts, real peerless in their field. So it's very nice for us to be able to publish this. I think it's a great article.
Excellent. Sounds really great.
Yeah. Okay, good. All right. So our second article then is titled "Towards Deeper Judicialisation: Explaining Thailand's Increasing Engagement with International Adjudication," by Phil Saengkrai, who is our colleague, of course, at Thammasat University. So it's very nice to have an article written by him. His specialism is, of course, international law, and this is again a very interesting and very useful, I think, article. This one is, and it's a good contribution to have. So what it talks about, as the title suggests, of course, is that we can see that Thailand is engaging a lot more with international adjudication, so different sort of forms of international law disputes, than it has been before. There has been this kind of move over sort of the last 2 decades, which I didn't sort of realise had happened. So traditionally, I've learned all this from reading his article, because this is not my field at all, really. But traditionally, Thailand has been kind of quite cautious of international adjudication, especially after sort of experiences which have not gone particularly well for Thailand, things like the Preah temple case, and I probably said that wrong, back in the 1960s. And since then, they've been quite wary, especially of the ICJ and the ICC. And they didn't ratify the ICC statute or accept its jurisdiction. They were worried about it being used for sort of political purposes and that kind of thing. But what Phil points out, what we've seen over the last couple of decades, is a big move, actually, a big shift in terms of being more willing to accept jurisdiction of international tribunals. Perhaps not so much the ICJ and the ICC, although there have been, I think, some moves in that direction. But certainly, like many other international tribunal types, so things like the dispute settlement under the WTO, also investor-state arbitration under bilateral investment treaties. So there's been kind of quite a shift there. So the other things that they did were things like they ratified the Law of the Sea Tribunal in 2011, and they continue to sign more and more bilateral investment treaties as well. And it seems like the ones that they are signing now, he says, are like they are becoming more sort of elaborate and more detailed, which suggests quite a lot of focus on using these. So not just to sort of increase investment in the kingdom, but also to protect Thai investors investing abroad. Again, it's been a sort of similar attitude of increased engagement with the WTO as well for their dispute settlement mechanisms. And he kind of highlights a few reasons why this might be, so why there is more engagement. And it seems that there is generally a global trend in this direction as well. Especially from sort of countries that have not been engaged so much before. There has been a move towards this. So there's been perhaps sort of a global trend towards proliferation of claimants, so more people who are able to claim through using these dispute resolution methods, and that's been a sort of a global thing, not just in Thailand, but it's in Thailand as well, which is one aspect of that. So sort of new litigants as well, and there have been sort of more law firms as well who are kind of work in this area, and in Thailand as much as elsewhere. But it sounds like that industry has been increasing as well, in particular. And the other sort of the final aspect, I suppose, that he talks about is that government officials as well. So from the government side, seem as well to be engaging in this more and more, and building their own sort of presence in the litigator communities. So they see this as being something that's like a specialism for them, or something that they can add to here as well. So it seems that Thailand is really kind of these are global trends, but it seems like Thailand is really engaging in that a lot as well. Yeah.
Right, I mean the trend towards increased arbitration around the world basically, and submitting disputes not to traditional litigation but really to arbitration. I think that is really also visible in Thailand as well. There are many very high profile cases now that are where the Thai government also is partly involved, that are playing a big role here. So it's interesting that in the commercial and trade area there is this really deeper engagement, while you initially mentioned that with regard to the you may say traditional parts of international law related to the ICJ or to issues of territory or these kind of questions, there may be still until today some hesitation. Also, you mentioned the ICC. Also there we may still see indeed quite some hesitation, which is not unique to Thailand, obviously. In Southeast Asia, I think there's generally this hesitation. But indeed, I mean, regarding the trade and commercial areas of international law, Thailand is really very much taking active part in that. Absolutely. I think that's it is interesting, and it does lead on to some further questions, which I think sort of Phil sort of raises in his article,
maybe as areas for future research rather than answering them. But I think one of the interesting things that he does say is perhaps, and this is again not my area of study or research, but he says, how much have international relations become judicialized? Perhaps this is, especially within Thailand or from Thailand's perspective. Perhaps there is increasing use of these judicialization generally. Maybe this is a different way Thailand is engaging in international relations. I don't know.
Yeah, I think it is true for trade and commercial areas indeed, where I think there's a consensus about the rules, and also maybe that a rules-based order is important for everyone in that regard. But I mean, as soon as it comes to the more sensitive issues that are related to territorial issues, maritime disputes, then I think we may still consider that it is often the right of the stronger, who may then not put themselves under some kind of litigation constraints, but may then just use other channels. But I think in this area, I very much agree that this is. I think that the world basically agrees to a certain set of rules, which are then indeed applicable everywhere, and where Thailand plays really an active role also in shaping these rules. So I think that is really interesting.
Yeah, I mean, that is another thing that he points out as well, is that Thailand has been quite active in sort of making submissions to these tribunals, even in a few areas where it doesn't seem to directly concern Thailand. So Thailand's been sort of making the government's been making submissions in disputes involving sort of African countries and things like that. So it is, perhaps it's just engaging more even when it's not directly concerned with some of these litigations. So I don't know. It's interesting as well when you say that they're perhaps still not engaging particularly in areas like territorial disputes and things, but they did ratify this the Sea Tribunal, the Law of the Sea Tribunal thing. So
right.
Maybe there is a shift, a gradual one.
Yeah, absolutely. I mean, I'm from my perspective, I'm following particularly the developments in international criminal law.
Yeah. So
and
how does that?
I mean, Thailand has signed, so that means they are also, at least you may say, bound to the extent that they should not do anything that would run counter against the interests or the purposes of the ICC. So therefore, there is a certain commitment there as well. It is just a matter of time, I think, until then Thailand may then also in that area consider now is the time for joining. When that will be remains to be seen.
So you think there has been kind of some movement, but maybe this might be one of the last things that sort of moves, or? Well,
yeah, I think it's difficult to say. For the ICC particularly, I would say that they were very early on. I think in 2001 already, only 3 years after that statute was made, they signed it, but that's now 20 years ago.
Yeah, true.
And since then, no major other movement has been made. Yeah. So therefore, it's a bit difficult to say that there has been particular development, but in the other areas that Phil points out in the article, that's a very different story.
Yeah. Okay. Great. Anything more to say about this?
No, I'm just giving here this kind of
off the cuff. That's why we
off the cuff. Exactly. Yeah.
Instant reactions. That's what we.
Instant reactions. Exactly. Highly qualified. Okay.
The third article then again is mine. Sorry, it seems to be all of mine and then all of yours, which is. I guess it is.
Maybe for the information of the viewers and listeners, we are basically following the structure of the table of contents to make it also maybe reflect what the readers will then see there.
Yeah, exactly.
So therefore, that's just basically the reason why now you are always you are now the third one already for you. All right.
Yeah. Okay. Okay. So the third one is law and identity. That's the third one I've got on my list anyway, is Law and Identity, the case of the common law of Scotland with comparative insights from Thailand. And this is sort of an article that's got two authors, so it's Kongsatja and Paul de Plessis. Kongsatja, again, is one of our colleagues as well, so it's nice to have Thammasat well represented in our inaugural issue. This again is a very interesting article. So it's another nice one to have in our first issue. It's sort of in two parts. So it's looking both at Scotland and at Thailand, and looking at it in quite a sort of quite a deep way, deep sort of philosophical way, I guess. But what it really does, I guess, is it looks at how in both of these systems, and it's interesting that both of these systems there is this similarity, both Scotland and Thailand, is that there is perhaps this exaggeration of kind of grand narratives. So grand narratives about like what civil law is, or what legal science is, and what legal science means. And so what their authors are sort of arguing, I guess, is that people working within those systems, so people writing, working, academics within those systems, are perhaps, I guess, trying to impose an understanding on their legal system that is perhaps trying to exaggerate the way that it fits into a particular grand narrative. So the narrative of what civil law is, or what legal science is, or trying to sort of trying to emphasize the fact that their legal system is a part of this other thing, and that's the way to understand it, and that doing that kind of misses a lot of the nuance, or a lot of the sort of the way that the legal system actually works, is at its sort of simplest level, I suppose. And so the way that the authors kind of do this is that they focus, so especially for the first part of the article talking about Scotland, is there's a real focus on kind of the mechanics of the system. So looking at the role of the courts, the sort of the status and the use of statute law within the system, things like this. And it seems that a lot of the kind of claims made by the writers of textbooks, and that's what they use to sort of to as the data for this article, is they look at kind of statements made by textbook writers in Scotland, and a lot of the things about what what's the status of some of these things are, like how statutes fits in, whether judicial precedent is a source of law, that kind of thing. A lot of that is kind of stated just by reference to these other grand narratives, and whether the law is part of sort of is supposed to be this kind of positivistic legal science kind of idea, and whether it's supposed to have this kind of this pure rationality and all fit together nicely, or not. And it seems that a lot of the claims that are made by the writers of textbooks seem to rely just on placing the legal system into this kind of grand narrative, rather than looking at actually whether this is how it works kind of on the ground. And a lot of the statements are just kind of quite sort of sweeping statements that are made, perhaps, that kind of thing. I suppose that was so with when looking at Thai law, there's also I guess there's another sort of another twist to it in Thailand, which perhaps isn't present so much in Scotland, which is this sort of you've got this kind of dichotomy between kind of Western trying to be Western but not Western. So having Western values or Thai values sort of in the same time in the system. So the idea is sort of how to be like the West but still be different, how to be kind of authentically civilian. So like trying to present Thai law as an authentically civilian system to give it the sort of credibility and authority as a good law that will work. But at the same time, trying to say that the Thai values are still important and they're authentic and they need to be preserved within the system too. But then that's also kind of assuming a sort of some unitary Thai-ness as well. So it's kind of it's fitting a few different narratives as well into the Thai experience. And it means, I guess, ultimately the authors, as they say at the end, they're not necessarily arguing completely against categorization, completely against using the categories of civil law or common law or anything else. But it's that the focus on these broad categories can lead you down the wrong path when you're trying to understand your system, because it just focusing on common law versus civil law. So, for example, saying this is an example that they use sort of at the end, which is Thai academics claim that Thai Supreme Court decisions don't have precedent power, but that's based on the fact that it's for lots of authors they just say that because it's a civilian system, and judicial precedents aren't a source of law in civilian systems. So that's you're sort of imposing the narrative on your view of the system, rather than necessarily looking at, well, is that the way that judges think, or is that just the way that we teach things?
Right.
Very interesting. Yeah, it is interesting. I think it is interesting. It's quite philosophical, but there's a lot of food for thought there, I think.
Yeah. That is also something that I think we also see very often when we read about Thai law, that often at the beginning of an article, of a master thesis or of a textbook, this very general categorization, first of all, is clarified, that Thailand belongs apparently to the civil law tradition. And I also sometimes think, well, why don't we just look at the rules, at the decisions, at the actual legal problems, and see how are they actually solved? And then we can say, well, here we have maybe some proximity to a civil law system, maybe here to a common law system, or maybe here to traditional Thai origins, you may say, or Siamese traditions, customary rules that have developed before. And I fully agree, and that I think also that there is now a younger generation, I think, of scholars that is more and more questioning that, and that is also considering that this very broad categorization does not really help to understand or to interpret Thai law. And I think also in practice, I mean, just particularly in criminal law, you can see that also, or in criminal procedure, it should somehow be a civil law country where you have certain rules, particularly regarding then how a court operates and how judges and lawyers interact, but the practice is often quite different. The practice looks more like in common law countries. So that, I think it is a very, very interesting comparison here, right? Because Scotland is also this kind of hybrid entity in the United Kingdom, which is not fully feeling maybe a part of the common law tradition, which has some civilian or civil law influences. And Scotland and Thailand have, I think, for many years have had very interesting exchanges. Many of our colleagues have also studied in Scotland, for example, and then they could make these connections between these two countries or these two jurisdictions that have a partly similar history and also current issues regarding the characterization or this categorization of the legal system. Yeah, really interesting.
Yeah, it is interesting. And you're right. I think that we do have a lot of links with Scotland in terms of our kind of scholarship and everything. And yeah, I mean, a lot of that is because we seem to have sent quite a few academics over there, especially the guys who are currently active in Thammasat University. There seems to be kind of a little school of them who went to Scotland and came back. But it is interesting that there are these parallels, between these kind of geographically very different countries. It's
right. I think really, I mean, when I just think about some criminal law textbooks, for example, also in Thai law, then very often the authors really at the beginning try to make the statement that they interpret and apply the criminal law from a let's say civil law perspective, and that is then the overarching theme for their work, where I might say, well, we might in many questions need to qualify a little. Yeah, we may not be able to continue or to keep up this one frame for the whole the whole discussion or for the whole investigation of the topic that we are doing. Yeah. All right.
And we both,
I think that's a very useful reminder.
It is a useful reminder. Yeah, absolutely. And we both had this that the same issue before that we've seen. I mean, we talked about this before, that often the in theses or articles, when people compare, the reason for comparing Thailand with some other law is often just that it's civil law, and that's sort of the answer. And I think that can be sometimes problematic, because often the actual rule that you're looking at in Thai law may not have that origin, may not have been transplanted from a civil law country. It may have come from somewhere else. Right. So yeah, I think it is interesting, and I especially like this kind of phrase, the grand narratives, because it is that it is that sort of attempt to fit into to be a true authentic civilian system.
Exactly.
Without necessarily looking at what the detail of that.
Right. Yeah. Very good.
Yeah. Anyway, okay. So I think is that my last one? I think that's my last one.
Okay, so then our next piece is Possibilities for Decentralization in Thailand, a view from Chiang Mai, which is written by Andrew Harding, our chief editor of Thai Legal Studies and a mentor for many students and scholars of Southeast Asian legal and constitutional studies, and Rawin Leelapatana, lecturer at the Faculty of Law of Chulalongkorn University. And their topic of decentralization is a topic that has been discussed really for at least now 2 decades or even longer, but we may say since the late 1990s. This has in Thailand been one of the main focuses of constitutional and administrative law. And in the article, they look at one particular example of a plan to further decentralize, which is the Chiang Mai Metropolitan Administration Bill, which was introduced in 2013. And since then, there has not yet been much progress, we may say. Nonetheless, they analyzed this bill before the background of the overall decentralization process in Thailand, which they also very nicely outline in the paper as well. So they start basically with different theories of decentralization and try to then situate the project that is taking place there, or that is planned there in Chiang Mai, into this framework. They also talk about the history of Chiang Mai, and they make basically the point that the development of decentralization in Thailand has been, you may say, a bit disappointing over the last 2 decades. So we may basically say the 1997 constitution, that's also what they argue, was a major, you may say, push for decentralization, at least for the first maybe 5 years after that constitution entered into force. But despite some advancements, but despite also some statutes, some acts that were made, also then institutions on the local governmental level that were created, nonetheless, they basically argue this rather highly centralized administrative structure that existed in Thailand for many decades before has still not really disappeared.
Right.
And the movements for decentralization have always basically been hampered by strong political influence from the center, as well as also limited resources, financial resources provided to the provinces and then to the local government units, so that no real, you may say, self-sustainable local government could really be created. So that before this background, they look at this Chiang Mai approach.
Right.
And for that, they argue that this is quite revolutionary if it ever became true, because in this Chiang Mai Metropolitan Administration Bill, it is a rather, you may say, high level of decentralization that that bill tries to create. So, and they even argue that even challenges the constitutional setup in Thailand, where if this kind of approach is going to be realized, not only in Chiang Mai but everywhere in Thailand, then that would basically reverse the central-local relations to an extent almost like a federal system, where then a big chunk of competence and power would be with the local governmental units, and also financially. So that that bill also wants to basically shift the financial contributions. I think currently it's about 30 to 35% of tax revenue that needs to be given to the provinces. And this bill wants to lift it up to 70%, doubling the number, which would basically mean the biggest part of the state budget would be going to the provinces, and only the remaining 30% would remain then with the center. But the most interesting element, I think, that they also refer to is a citizen assembly that this Chiang Mai bill wants to create, which shall be a bit of a counterbalance to the executive institutions that are created, so that a very strong democratic element, and this citizen assembly, according to this bill, they argue should have the same standing like the executive authorities, so it should really be a counterbalance. And interestingly, however, and that reflects this Chiang Mai history and also this approach there, they argue, this citizen assembly shall not have any votes, any hard votes, but it shall really only deal with the issues that come up by way of deliberation and then
Wow.
a consensus.
Okay.
So the goal
That's
is
very
always the
interesting.
consensus, no hard votes.
Wow.
I think also that is quite an interesting feature. So
Yeah.
overall, I think that paper is really fascinating.
Yeah, that is fascinating.
They are themselves a bit skeptical whether that will ever become reality
Yeah.
in Thailand, but nonetheless, it is worth discussing, I think.
Yeah, it sounds like a big change, to say the least, from what's here already. I'm very interested by this citizens' assembly idea. So, what kind of issues then would go to the citizens' assembly? Because you sort of mentioned the executive. So, is it sort of oversight of executive more than legislature, or is that what it is?
Right. Yeah. Exactly. It seems to be more an oversight body that can look over what the executive authorities do, and thereby really be a checking, counterbalancing authority, so that there is a more direct involvement. But I mean, the governors and also other administrators should also be subject to election, which is already
Right.
partly the case now for local government. But for example, currently the provincial governors are still appointed by the Ministry of Interior.
I see.
So this citizen assembly would be another democratic element, so that is really then pushing local governments to another level of democratization.
see.
So that seems to be really quite an interesting element. I agree. Yeah.
Yeah, fascinating. So and do the authors did they come across as being quite in favour of this approach, or do they think do
I
they
think
like
so.
it, but they think
Yes,
it's hopeful?
very much.
Yeah, very much. Okay.
I think Andrew and Rawin are both very much convinced that decentralization would be very beneficial for the governance of Thailand in general, because I think they believe that many problems could be solved much better if they are solved locally. For example, they start their paper with the haze problems in Chiang Mai that
I
now
see.
occur on an annual basis. We also have the same in Bangkok sometimes, but in Chiang Mai it is much worse for some months. And they basically argue, well, currently you cannot really blame anyone that it's not solved, because no one really has the power. So the Chiang Mai governor doesn't really have you may say, the local knowledge and backing, because he is put into his office by the Ministry of Interior, but also the central government is in itself too far away. So they argue these local problems, one example is the haze, but also others, may be better resolved if they are resolved locally, where then also, for example, this kind of conflict resolving, a bit of a deliberation, discussion, not only hard orders, stop this, stop that, but then also maybe taking into account the local customs, how people get along with each other and how they can together solve a problem. And I think that's also what they favor, I guess, that people in a certain locality can approach a problem also according to what they consider is the best interaction between those who are involved.
Yeah, that's a very interesting take on it, because I mean the sort of the smog problem is that's an interesting one to look at for this, because it's almost counterintuitive, because that's something that seems like it's such a big problem, and it covers people in different countries and different borders, and the pollution obviously doesn't respect jurisdiction. So it seems like that would be something that you would want to solve from at a sort of national to national level, the sort of international level.
Right.
But actually, it's interesting to
agree.
take a sort of to say that maybe the local approach is the way to address this. I don't know. Interesting.
Well, I think for the haze problem, we may really say only the locally produced haze or smog can be approached with that. So what comes over from other countries, there might be an international solution then necessary. But
also,
that's right. I was
suppose,
also a bit surprised, because I also, for Bangkok, for example, I also sometimes think, well, you cannot really break it down to one province where the smog comes from. It seems to be really a larger issue. But I think for Chiang Mai, just regarding the haze now, it seems that the location of the city in this valley means that all the smog or all the fume that is produced around it, it just stays there. So if you first of all clear up the surrounding areas, that would, for the city of Chiang Mai, already bring a lot.
Yeah. And I suppose also it means that, I guess, a local issue, or an issue that impacts people locally, can then be kind of raised to the level that the government's really taking action. The local government is,
right.
Which then, I guess, may then sort of push international stuff as well, because they can push maybe Thailand at the national
Exactly.
level. Maybe that would help too.
I mean, the great thing about decentralization, or in the end even federal systems, is that you can try out different things in different places and see what works. And then in the end you choose the best approach. While if you only have one centralized approach, you will never know how other approaches would have worked because you didn't try them.
Yeah, true. Yeah, good point. So why do they think it's going to fail? Or why are they not hopeful? Just because it's such a radical change?
Exactly. Yeah. So just because I think they don't believe that the central government is willing to make these radical changes. I think it will be a gradual process. But they also argue, even though this gradual process has for a certain while taken place, there have been these political turmoils and then also military coups that then cut off the developments. And therefore, they argue that, well, if this cycle continues, then they are not very hopeful.
Yeah.
On the other hand, they also argue that this decentralization and the stronger involvement of local population in also relevant issues in that locality will also overcome the divisions in society, because people will feel that they actually can cooperate with each other and can together come to solutions. So that, for example, this red-yellow divide that they also mention in the article, that could be overcome, because interestingly, this Chiang Mai bill is supported by both sides. It's supported both by the red and the yellow side. So it is really one example where a consensus about at least this fundamental question of how do we in the future want to govern our province, that has found the support of both sides, quite interestingly.
Yeah, that is interesting. Yeah.
All right, shall we go to the next piece?
Yeah, let's do it.
All right, so the next one is Women Lawyers for Social Causes, Professional Careers and Legal Development in Thailand, written by Frank Munger, Peerawich, Thoviriyavej, and Vorapitchaya, Rabiablok. And the topic of this article is, as the title says, to look at the careers of three particular women lawyers that or who are described by the authors as possible also role models for others. But the authors look particularly at their background, their careers, and tie that very nicely to the development of the legal profession, and particularly women in the legal profession in Thailand over several decades. So they also then break it down into different eras that they want, or that they distinguish for their analysis. So they would look, for example, in the early years, you may say, since the 1932 revolution, then to the October years in the 1970s is the first part, then the October years and the following years, and then up to the 1997 Constitution, and then to modern times. Yeah. And they are able to distinguish here different persons and personalities that were particularly influential for women lawyers, who were basically role models and then influenced also others. And I think this is really a fascinating paper, a very rich paper, which connects Thai history, the legal the development of the legal profession before this historic background, where you obviously also had different political eras, and then they focus on women lawyers in this particular field of social cause lawyers. So the article then proceeds basically to, first of all, set a certain framework, and they say that their analytical point, or their conceptual aspect here, is so-called capital. So they say the women lawyers have been able to accumulate a certain capital over their individual careers, but capital, they use this term not in the financial way, but they basically say, well, capital here refers to, for example, a certain family background, a certain education, obviously, but then particularly networks that they have been able to build over their careers. Yeah. And also then, for example, connections with the NGOs and a certain internationalization of their profession and also of their own practice. And all these elements together basically are then contributing to each of the three women who are presented here in more detail, to their careers and to their success. So the authors also argue that these three lawyers that they present are really the leading lawyers for social causes. So that means, for example, for environmental litigation, for human rights litigation, for land ownership litigation, where they are representing usually communities or individuals who are not that well off and who are facing, usually state interventions into their livelihoods, but sometimes also interventions by private companies who are developing a certain project. And then these are the lawyers who are defending then these groups or these individuals, and they seem to be very successful and are therefore really, you may say, shining stars in the social lawyers scene, but they are all women. And I think the interesting aspect of this article is really, on the one hand, the connection between these three careers and the overall development of the legal profession, but also then their individual biographies, which are really laid out in quite some detail. So this is a rather long article, but an article that then really takes the time for each of the three to look at where did they grow up, what was their education, what kind of networks were they able to build, who did they get to know, and how did all of that contribute to their very successful career. I think one interesting point is at the very, very end of this article, which is a bit disappointing, we may say, because at the very end they say, even though in this area of social cause lawyers, these three lawyers have been very, very successful, but nonetheless the authors are skeptical whether such a success and such a, you can say, upward mobility would be possible to positions of greater influence in other areas.
I see. Okay.
Not social lawyers or not social cause lawyers. And they are very skeptical because they still believe that the legal profession is still a rather conservative profession where usually men take the leading positions. But in this, you may say, niche of social cause lawyers, they argue here that is really an area where women have been particularly successful.
Is there any particular reason they give for that, or is it just that perhaps it's just one of these things that's happened, particularly in this niche? Do they give any kind of cause for this?
I think one of the arguments that you can maybe see more between the lines is that perhaps there is a stronger interest by women. I think that's always difficult to categorize, but at least here you may say, at least these women have been particularly interested in then working for social causes, even though they have also had you may say, more normal legal career before, but at a certain point they decided, let's go into this area, even though it may mean that in terms of my career, in terms of, you can say, the payments, the salary that I will receive, I may not be advancing that much, but I do it for the good cause. And I think you can find men and women doing that, so I think that is not really only a women's domain, but perhaps there is an argument to be made that at least these three women were saying, well, I don't care about career. I want to use my legal knowledge for these causes.
Yeah, I see. And did the three women, did they have quite similar careers before this, or sort of in their background?
There have been really quite some converging points. For example, two of them did an internship in the same institution, which was, I think, the Asian Human Rights Commission, where they got to know each other and also other practitioners in the region here in Asia. Some of them had the same professors at the university who were supporting them as well, which is, I think, also that's, I think, also for us as law lecturers very encouraging that for these three lawyers, maybe the biggest inspiration at the beginning of their career were really their law lecturers, and they wanted to to pursue the goals that their lecturers also presented to them, and the lecturers were apparently also very active in supporting them and willing to show them possibilities for their future career, and so it seems that our students are really looking at what the lecturers are doing and what they might be suggesting. So I think that's also a very positive notion
nice
on our profession.
Yeah, that's a good reminder. Wow. Okay.
Right.
Sounds like a very interesting article. I like the idea that it goes very deep into the backgrounds of these lawyers as well. Yeah, that's kind of quite unusual. But yeah, good.
Right.
Yeah. All right.
All right. Take it away.
All right. Yeah. So let's get to the next piece, which is written by Piti Eimchamroonlarp, who has written about the rights to own and operate a hydro floating solar project in Thailand. And this article is, I think, very timely because it deals really with perhaps one of the future technologies with regard to electricity generation. So he basically writes about solar panels on water. Yeah? So these solar projects, or these hydro floating solar projects that he refers to and that he then considers with regard to their legal feasibility, are now indeed starting in Thailand. Oh. So there is the first kind of project already that has been, or that is under construction on one particular water surface that is next to a dam, so where there's obviously quite plenty of space to try that out. And so it would basically be solar panels on water, which in Thailand obviously I think guarantees indeed quite some hours per day of electricity generation. So therefore, that's a very interesting technology. So that is also described a bit in his article. And Ajahn Piti from Jula, obviously, from the Faculty of Law, is then looking at, well, what is here the legal regime? What are the laws that are applicable here? And are there any obstacles that would currently exist with regard to such a project, or are there any legal changes necessary? And interestingly, he basically says no, we can do this under the current law.
Oh, that's good.
So the relevant licenses can be provided, power purchase agreements can also be made based on these kind of projects. And also the structure of the industry, which is basically this kind of single buyer regime where the state basically buys electricity from all kinds of also private electricity generators, but they must be then recognized by the state. But the state is basically the single buyer of electricity. But also that, he argues in his paper, I think very convincingly, is not an obstacle. So also that is basically just then, you may say, this new technology would then be fit into this kind of regime. I think this is a very informative article, also about the role of different agencies, about, for example, the Energy Regulatory Commission, which always has to, you may say, approve and supervise these kind of projects. So I think also for everyone who is more a practitioner in Thailand, or who is interested in perhaps setting up such a project by himself, this I think is a very nice outline of the legal requirements, and also the some unresolved legal questions that may still remain. So one caveat that Ajahn Piti here has inserted into his article is that the question of who owns public water surfaces, that is an issue that he discusses. So for example, this water surface where this trial is now, or where this first project is being constructed, that is basically public water. I think basically all lakes and other water surfaces are generally in Thailand public water surfaces. Right, okay. I mean, maybe there are some private ones also, but I think generally the state owns them. And then the question is, well, if someone like a private investor, for example, wants to realize such a project, what kind of arrangement would be necessary there? Because also he argues, I think very convincingly, if an investor needs money from a bank, for example, some bank loan in order to get this project started, then one of the bankability factors is also right, exactly. So one of the bankability factors would be, well, do you have also some property that could be like the collateral for the bank, right? If then the water surface is not in the hand of the private company, then there needs to be some kind of arrangement, perhaps also in that regard, to make sure that this is also taken care of, so that there's clarity about the arrangement between the state, that is most likely then the owner of that water surface, and then the private project owner or the company that is then in charge of doing that. But I think also there, Ajahn Piti, I think, is here very optimistic, I think.
Oh, right. Good.
And I think argues that this is a technology, but also a legal area or legal field that is very promising for the future,
right.
and where most likely there are not many problems, and if there are some, then I think he's also of the opinion that these could be resolved. So, I think really a very interesting piece.
Yeah, some good news. Perhaps a very ignorant question. Why are they putting them on water?
Well, because I think that is just a space where no one is annoyed by them, right?
Oh, I see. Okay. So, like, if you've got like a big dam or something,
additional,
so like a big piece of water you're not using.
Yeah. So the water surface is existing anywhere, so nothing else could be built there.
Yeah.
So it doesn't consume any space on land, and the materials which are used for these projects are also without any harm to the environment below. So the water or the species in the water will also not get any damage. Although I myself asked the question to myself, what about the light? So the light, which is then basically blocked by these water, or by these panels, these solar panels on water, isn't the light also important for the fish and other animals in the water? And I think it might be important.
Yeah.
So I'm not quite sure whether this kind of environmental impact is just not a big issue, or maybe I'm just mistaken about that.
I don't know. I mean,
but that would be
be
something.
a deliberate thing, because I saw a documentary, I think, on Netflix, where I think that because obviously water kind of security and access to fresh water is becoming like an issue, and I think it was in the US. I'm sure it was probably the US, where they kind of covered the surface of reservoirs. I think it was. With these kind of dark, like, floating ball things.
Right, I've seen that too.
You've seen it as well.
Yeah.
So maybe it's a similar kind of idea. Maybe if you put the a bunch of those on a bunch of the solar panels, maybe it will stop the evaporation. I don't know.
Right. Yeah, that's possible. I mean, and maybe also in these lakes there is. I mean, I think that documentary also. I think I might also have seen that maybe there was no substantial wildlife in that lake.
Because
anyway.
I think it was like a reservoir, so it's supposed to be like drinking water eventually.
Exactly.
So I think they were sort of trying to discourage wildlife rather than.
Right. Well, I think the lakes that are produced by these large dams. I think there is still significant fish and wildlife in it. I mean, wildlife is maybe not the right word, but maritime life. So that I don't know whether there's any impact, but it seems that it is at least not a major concern, or maybe also that still enough other parts of the lake remain without it, so that maybe only then some parts are covered.
Still, right. Interesting. Nice that it's like good news for once. It's not saying that there's no way this thing can ever happen. Like, at least it sounds optimistic.
Exactly. I mean, I was also quite surprised, because I always thought the only power that is generated on the sea would be windcraft or wind power. But solar power, as long as it is not the high seas where you would have, I think, too strong waves. But as long as it is on lakes, why not solar power on water?
It's a good idea.
Quite interesting.
Yeah, good.
Okay, so then the last piece on our first issue is an article that I have written together with Pudit, Ovattananavakhun, and we have, the title of the article is Thailand's Law on Criminal Online Falsehoods, a Critical Discussion. And in our article, we look at one particular piece of legislation in Thailand, which is the Computer Crime Act, and there we look at particularly one provision that deals with the criminal liability for spreading false information online. And we basically argue that this is a trend that also is occurring not only in Thailand, but in Southeast Asia and the world in general, that this age of fake news has now produced a lot of responses, and also a lot of criminal responses, where then some countries have indeed created criminal laws to fight fake news. And in our article we try to say that, funny enough, Thailand has been a front runner in this development, because already 2007 this Computer Crime Act was enacted, then it was amended in 2017, but the original version, so also the criminal liability for spreading falsehoods online, that goes back to 2007 already, while, for example, if you take a look at Malaysia, Singapore, Philippines and other countries here in the region, they came just in the last 2 to 3 years.
Right.
To criminalize that, but Thailand had it in place very early already. So at the beginning we tried to set this out, this general legal development here in the region, but then we focus very much on the Thai Act, and I think this provision or these provisions that deal with the criminal liability for spreading fake news online have a lot of problems regarding their interpretation. So we look at the legislative process, we look at what were the different stages, the different proposals along the way, and there's quite some change in the approach. So initially, it seemed that the drafters wanted to tackle the you may say the trustworthiness of information. So they just wanted to create a law that would make data forgery a crime, to forge data, because the general criminal law only has forgery of physical documents, so they said, well, that doesn't match with data, so we need a specific provision. So that was the initial focus, forgery.
Yeah.
But then another aspect was added to this law, which was then also looking at the content of the information, whether the actual content was correct or not correct, so true or false. So that then also false information, regardless of whether it was forged, but if it was from the beginning just a false statement of fact, then it would also be
different
punishable.
Things, aren't they? Like,
different thing, One is the trustworthiness, the other one is the truthfulness of the information, which are two different issues. But they have then been merged in the same provision. And also, there are then two subparagraphs there which have an overlapping reach, both dealing with false information, so that there are quite some issues regarding, first of all, the structure of this provision, but then also some interpretational problems that I think need to be overcome. Particularly, we argue that one problem in the application of these laws, not only in Thailand, if you take a look at, for example, the Singaporean law, you see the same issue, is that the publication of false information is only a crime if that publication is likely to affect certain other interests.
Right.
But it does not have to actually have that effect. It is just likely. So even though something has been published and then nothing happened, so no one went crazy, or no one was having any particular response to it, or there was no other impact really. But then still, a court could say, well, but it was still likely, it could have happened. And then obviously the question is, what is the level of probability here, and how do you prove that? If the facts show that actually nothing happened, then you can still basically say, but it was still likely, it could have happened. So we also look a bit at that, which is not a unique phenomenon for the Thai Act. You find that in legislation around the world that use these terms of probability or likelihood. Well, and then finally, the final aspect, if I just may also say that, the final aspect is then the constitutionality of it.
Right.
To what extent do we have here a disproportionate restriction of free speech? So many countries are obviously looking at what do we do about fake news. And that is, I think, also right, because fake news are a problem. Nonetheless, one aspect is, okay, what do we do about that? Do we need to use the criminal law, or do we have other alternatives? There are obviously other alternatives as well, as we can see that social media can maybe do their part. They may filter out some content themselves so that we may not need to punish anyone, or we may increase media literacy. That can be another approach. There are other solutions as well, but if the criminal law is chosen, then it needs to be a proportionate response. And there we argue that one recent constitutional court decision in Thailand actually is helpful to argue here, to say that perhaps the current regime is a bit too harsh.
Okay, interesting.
Because very interestingly, the Thai Constitutional Court in a recent decision has established a standard for proportionality where you usually have a problem. Okay, what is proportionate? What is excessive? What is... And they basically said in one decision last year that one particular case, one particular decision, they said that law is too harsh if we compare it to another law, because the two laws are dealing with almost the same issue, but one has a much harsher punishment than the other.
Right.
So that means the very harsh punishment is disproportionate.
Ah, okay. So
whether that is fully convincing is another question.
Yeah.
Exactly. I mean, you can also say, well, maybe the other punishment is just much too low.
Yeah.
Well, that's another approach. I mean, depends on your viewpoint. But there they said that harsh law is too harsh. And here we then argue, well, interestingly enough, there is a provision in the Criminal Code of Thailand that already deals with the malicious publication of false information that could cause panic.
Okay.
And the interesting aspect is the punishment for that is 60 times less than what you find in the Computer Crime Act. So the Computer Crime Act has increased the punishment by the factor 60. And we might say, well, if we now take a look at recent Constitutional Court jurisprudence, maybe we can apply the same reasoning here, and then maybe that is also an example for such an, you may say, a bit disproportionate approach.
Yeah. Interesting.
Exactly.
Very interesting. I did read the article, but it's obviously it's not exactly my area, and obviously it's yours because you wrote it. But one thing that I wondered is, do you feel like Thailand was actually kind of disadvantaged by being a forerunner here almost? Because I guess if this thing was done in kind of 2007, the internet and the online world, I guess, looked quite different back then. I mean, not as different as in the mid-90s or something, but still kind of quite different. Whereas I guess if for countries that are developing laws post kind of 2015, 2016, when kind of fake news became sort of part of kind of popular consciousness, do you think that a different approach would be taken, or do you think that they probably still would have done sort of taken the same approach? It's a difficult question to answer.
I think that's a very interesting question. That's really hard to say. I mean, the Act has been amended in 2017.
Right. Okay.
And we even argue that also these amendments have actually not contributed to more clarity, even though that was in 2017. So, but that was still before, for example, the Singaporean Act.
Right.
Although it seems that in this area, countries are not learning that much from each other, it seems.
Interesting.
But as this is related to free speech, it is a highly political issue as well.
Yeah.
So therefore, it seems that countries do here what they consider best for their own setting. And therefore, for example, in Malaysia, for example, a fake news act was enacted in 2018, and that was really sweepingly wide, so that there people argued, well, maybe here the government may even have a certain hidden agenda to maybe crack down on dissenters. Interestingly enough, that law was then also taken off the books again, so that was repealed. Was considered to be too far-reaching. While Thailand has chosen a different approach, has indeed limited the applicability to certain cases where a certain public interest is actually, or not actually, is likely affected, but it is still a rather wide reach. It's still a rather wide reach. So, but I mean, it remains to be seen whether further amendments will be made, and this is really an ongoing development, the fake news legislation.
Just again, the very, I guess, a final question is like, and I can't remember if this is in your paper or not, but is this act used a lot, or do I mean, I don't know if that's part of your research or not. Like, is it sort of regularly used in prosecutions?
Yes, it is. So the act is indeed used. So very interestingly, also until 2017, until the amendment, it has been used very often for defamation cases, even though that was not what the legislators wanted.
Right.
And that was then actually changed in 2017, where it was then made very clear that defamation should not be covered under this act, explicitly then excluded. But the law has still also since then been used for these kind of falsehood cases, where then people have been the subject of investigations for publishing false content online. So that act is indeed in use. So there is also a database online where you can see basically a case tracker, where new cases are added also, and that is very frequently updated also.
Okay, interesting. Okay, fantastic. Thank you very much, and thank you for your contribution to the journal on behalf of
Right.
Okay, so the final piece of material, I guess, for our first issue is a commentary. So we have a commentary at the end, which I guess we can just say a few words about, since might as well. Which once again is written it's entirely by staff in the Thai legal studies, because it is again Lasse Schuldt and Pimtawan Nidhi-u-tai as well, who's our associate editor, one of our associate editors. And the title of the commentary is Supreme Court Jurisprudence on Corporate Criminal Liability, 2010 to 2020. So perhaps you could tell us a bit about that.
Okay, just a few words. So this is basically a short commentary on some developments in the Supreme Court jurisprudence over the last 10 years regarding corporate criminal liability in Thailand under Thai law. Well, the field of corporate criminal liability in Thailand is really one that is maybe subject to the most criticism by legal scholars in Thailand in the overall criminal law area.
Right, okay.
It's really interesting. So you don't really have many areas of law, maybe also generally, where there's such a resistance against the Supreme Court in legal scholarship.
Oh, interesting. I didn't realize that.
It's really, so you find almost only comments who say, well, what the Supreme Court is doing here is against the rule of law even, because they argue that, maybe as a bit of a background, at one point the Supreme Court has decided to just apply general criminal law, so these kind of whoever provisions, whoever did will then be punished, that these provisions are also applicable to legal persons, which was quite a surprise for many.
Right.
And that is, however, nowadays absolute accepted jurisprudence. But the scholarly criticism just doesn't stop. Right. And scholars still demand, well, we need specific legislation for that. Otherwise, when the criminal code was drafted, no one thought that these provisions could also be applied to legal persons, so we cannot just do that. However, we may even say, because this is now going back more than 60 years, I think, that more than 50 years that that decision was made by the Supreme Court, that these provisions can be applied. So you may even say now, after half a century, there is now enough legal clarity, and no one can really be surprised anymore. Nonetheless, that is not the focus of our commentary. That's just a bit of a background. We look at some more recent decisions that expose other problems. So the doctrinal problems regarding corporate criminal liability are not ending there. So there are also other issues, for example, regarding the question whether a legal person and a director of a legal person can be joint principals. And for that, we, for example, me and Pimtawan, we argue that that is not possible, because a legal person cannot itself have its own will, because for a joint principles you need to have a common plan. Well, the director usually makes the plan, and then there will also be liability for the legal person, but the legal person cannot join into the plan, you may say. It's an interesting issue. So we look at some of these developments over the last 10 years.
Okay. Excellent. Well, that brings us to the end, I think, of our first issue. So thank you so much for being willing to get together with me and discuss for hours and hours. I think it will be now our first issue. So just, I guess, a message to people watching. Thank you for watching, and goodbye.